Hey everyone. Tonight we're diving deep into the strange, often absurd world of medieval lawmaking. You see, we often think of laws as these carefully considered, rational responses to social problems. But in medieval Europe, many of the most important laws that would shape society for centuries, came not from careful deliberation, but from single, utterly ridiculous incidents that spiraled completely out of control. Tonight, we're going to explore how a pig's trial for murder led to centuries of animal courts, how a knight's drunken mishap created Europe's first drunk driving laws, how a baker's artistic ambition nearly got him executed for treason. These aren't just amusing historical footnotes. They're windows into a world where logic took long naps, where superstition ruled supreme, and where the line between sacred and profane was drawn in the most unexpected places. So, settle in, get comfortable, and let me tell you the extraordinary story of how medieval Europe created its legal system one bizarre incident at a time. This is a journey into a world where even pigs needed lawyers, where geese could be knights, and where the simple act of baking bread could be considered an act of rebellion against God himself. Picture this. It's 1386, in the small French town of Falaise. The morning mist clings to cobblestone streets, church bells ring out across red-tiled roofs, and somewhere in this picturesque medieval scene, a pig is about to make legal history. The pig in question was ordinary in every way, nameless, unremarkable, owned by a local peasant family. She spent her days rooting through garbage, wallowing in mud, and doing all the things that pigs have done since the dawn of time. She had no idea that on this particular morning she would become the defendant in one of the most famous trials in medieval history. What happened was tragic and simple. A young child playing in the street caught the pig's attention. Perhaps the child was carrying food, or maybe the pig was simply hungry. In an instant of animal instinct, the pig attacked, seriously injuring the child. The child later died from the wounds. In our world, this would be a terrible accident, the kind of thing that leads to regulations about livestock containment, perhaps some compensation for the family, certainly the slaughter of the pig. But this was the Middle Ages, where the boundary between human and animal, between reason and faith, between accident and sin, was drawn very differently than it is today. You see, medieval people lived in what we might call a moral universe. Everything, every creature, every action, every event existed within God's grand design. Nothing happened by accident. If a pig killed a child, it wasn't just an animal acting on instinct. It was a moral agent making a choice, and moral agents could be held responsible for their actions. So the townspeople did what seemed logical to them. They put the pig on trial for murder. The trial was conducted with all the solemnity of a human murder case. The pig was formally arrested, yes, arrested, and confined in the town jail. A bailiff was assigned to guard her. A court date was set. Official documents were drawn up, charging one pig of unknown name with the willful murder of a child of tender years. But here's where it gets really interesting. Under medieval law, even pigs had rights. The court appointed a defense attorney, a real lawyer, trained in canon and civil law, who now found himself in the rather unique position of defending a pig's life before a jury of her peers. Well, not literally her peers. The jury was composed of 12 respected men of the town, but you get the idea. The defense lawyer, whose name history has mercifully forgotten, crafted what was actually quite a sophisticated legal argument. He pointed out that animals, lacking rational souls, could not form the intent necessary for murder. He argued that the pig was acting on natural instinct, not malice. He even suggested that the child might have provoked the attack through careless behavior. The prosecutor countered that the pig's action showed deliberation and malice aforethought. The attack, he argued, was sustained and vicious, going beyond mere defensive behavior. Most damning of all, the pig had shown no remorse after the act, a clear sign of a hardened criminal mind. The trial lasted several days. Witnesses were called. Evidence was presented. Legal precedents were cited. Finally, the jury retired to deliberate on perhaps the most unusual case in the history of jurisprudence. Their verdict: guilty of murder in the first degree. The sentence was death by hanging, the same method used for human murderers. because consistency mattered in medieval justice. But the story doesn't end there. Oh no, it gets much stranger. The pig's execution was carried out with full ceremony. She was dressed in human clothing, a shirt, breeches, and a jacket, because a condemned criminal should face death with dignity. She was led through the streets to the gallows, where a crowd of hundreds had gathered to witness this unprecedented spectacle. The executioner performed his duty with professional competence. The pig died, probably very confused about the whole affair. Justice, according to medieval logic, had been served. But the case caused an uproar that reached far beyond the walls of Falaise. Word spread throughout France, then across Europe. Some people applauded the careful application of justice to all of God's creatures. Others worried that the whole affair was getting dangerously close to blasphemy. The Bishop of Lisieux, whose diocese included Falaise, was particularly concerned. If every parish started executing animals on its own authority, who knew where it might lead? What if they started trying cats for witchcraft? Dogs for theft? Where would it end? And so, within months of the pig trial, the church issued a new decree. No animal could be tried for a crime without explicit ecclesiastical authorization. In other words, even pigs now needed permission from God's middle management before they could face justice. This might seem like bureaucratic overreach, but it actually created something remarkable: the world's first systematic legal framework for dealing with animal crimes. Over the next several centuries, hundreds of animals would be tried in European courts. Roosters accused of witchcraft for crowing at unusual hours, goats charged with immorality, cows fined for trespassing. Even insects were sometimes brought to trial, though getting them to appear in court proved challenging. Each case had to be approved by church authorities, who developed elaborate procedures for these trials. Animals had to be formally served with legal papers, though how one serves a subpoena to a grasshopper was never entirely clear. They were entitled to legal representation. They could even, in theory, appeal their convictions to higher courts. The most famous of these cases involved the rats of autumn. In 1522, the rats of this French city were accused of destroying grain crops and generally making nuisances of themselves. They were formally summoned to appear in court, but failed to show up for their trial. Their court-appointed attorney argued that his clients were too afraid of the local cats to safely travel to the courthouse, an argument that the judge found so persuasive that the case was dismissed. To modern eyes, these trials seem like elaborate jokes, but medieval people took them very seriously indeed. They reflected a worldview in which every creature had its place in God's hierarchy, and every action, whether by human or animal, had moral significance. This wasn't primitive thinking. It was sophisticated theology. Medieval scholars had spent centuries working out the relationship between divine will, natural law, and human justice. They believed that God's justice was perfect and universal, extending to every corner of creation. If God could judge sparrows, surely human courts could judge pigs. The animal trials also served practical purposes. They provided a way for communities to process traumatic events, to assign blame, and achieve closure. They reinforced social hierarchies and religious beliefs. And yes, they eliminated dangerous animals, though they did it in a way that preserved the community's sense of moral order. But perhaps most importantly, these trials established the principle that justice was universal. No creature, no matter how humble, was beneath the law's notice. This was a radical idea in a world where justice was often arbitrary and capricious, where the powerful could escape consequences while the powerless suffered. The pig trial of Falaise didn't just create a new body of animal law. It helped establish the idea that law itself should be systematic, predictable, and fair. It was a small step, perhaps, but it was a step toward the world we live in today, where even the humblest citizen can expect their day in court. If you think a pig standing trial for murder was the strangest legal case of the medieval period, let me introduce you to Sir Hiss of the Pond, a knight whose brief military career would reshape the laws of chivalry across Central Europe. It's the 14th century, somewhere in Bohemia. The exact location has been lost to time, but the story has survived in chronicles that read like fever dreams. Picture a typical medieval tournament: colorful pavilions dotting green fields, knights in gleaming armor testing their skills, crowds cheering for their favorites, merchants selling everything from blessed relics to questionable meat pies. Tournaments were the sporting events of their day, but they were also much more than that. They were displays of power, opportunities for young knights to make their reputations, and carefully orchestrated theater designed to reinforce the values of medieval society. Honor, courage, skill at arms, devotion to God and sovereign, these were the ideals that tournaments celebrated. But by the 14th century, tournaments had become somewhat routine. The same knights, riding the same horses, following the same elaborate rules, putting on the same carefully choreographed displays of martial prowess. It was all getting rather predictable. Enter our unnamed Bohemian nobleman, a man history remembers only for his sense of humor and his complete lack of common sense. Bored with the predictability of tournament culture, he decided to liven things up with what he probably thought was a harmless prank. He commissioned a complete set of miniature plate armor for his pet goose. Let that image sink in for a moment. A goose, that most belligerent and unpredictable of barnyard birds, dressed in custom-fitted medieval armor, complete with a tiny helmet. The nobleman had the armor crafted by the same artisans who made gear for human knights, with the same attention to detail and quality of materials. He named the goose Sir Hiss of the Pond, registered him as his official squire, and announced that the bird would be participating in the tournament's opening ceremonies. The other knights thought this was hilarious. Here was a man so confident in his own martial prowess that he could afford to mock the entire institution of chivalry. It was the medieval equivalent of showing up to a Formula One race in a decorated shopping cart. The crowd loved it too. Medieval people had a well-developed sense of the absurd, and the sight of a noble goose waddling around in tiny armor appealed to their appreciation for both spectacle and satire. But geese, as anyone who has spent time around them knows, are not particularly concerned with human entertainment. They are proud, territorial birds with minds of their own, and absolutely no sense of humor about being dressed up as medieval knights. During the tournament's opening procession, Sir Hiss apparently decided he'd had enough of this nonsense. According to the chronicles, he somehow escaped from his ceremonial perch and went on what can only be described as a rampage. Picture the scene. A fully armored goose, flapping and hissing with fury, charging through crowds of startled spectators. The tiny armor didn't slow him down. If anything, it seemed to give him confidence. He attacked anyone who got in his way, his beak enhanced by a miniature metal beak guard that turned every peck into a genuine weapon. A squire tried to catch him and got bitten on the hand for his troubles. The goose then set his sights on larger prey, a destrier, one of the massive war horses that knights rode into battle. These were animals bred for courage and trained to face the chaos of medieval warfare. But apparently no one had prepared them for an assault by an armored waterfowl. The horse panicked, reared, and threw its rider, a knight who landed heavily in front of hundreds of witnesses. This triggered a chain reaction. Other horses spooked, their riders struggled to control them, and within minutes, the carefully orchestrated tournament had dissolved into chaos. When the dust settled, 3 knights had been injured, 2 horses had been seriously hurt, and Sir Hiss of the Pond was very much dead. Trampled, ironically, by the very horse he had terrorized. The injured knights were not amused. Neither were the tournament officials, who had spent months organizing an event that had been ruined by a single goose. The church representatives were horrified by what they saw as a mockery of the sacred bonds between knight and squire. But it was the legal implications that really worried the authorities. Medieval law was very specific about what constituted legitimate knightly behavior. Knights had privileges and responsibilities that were carefully defined by centuries of legal precedent. If anyone could simply declare a farm animal to be a squire, what did that do to the entire system of feudal obligation? Within a week, an emergency council had been convened. Legal scholars, church officials, and representatives of the knightly orders met to determine what laws, if any, had been broken, and what measures should be taken to prevent similar incidents in the future. The result was a remarkable piece of legislation that modern historians call the Goose Decree. Its official title was considerably more verbose, but the essence was simple. No person, regardless of rank, could bestow titles of nobility upon animals, dress animals in the regalia of human warriors, or include animals in ceremonies reserved for human participants. The decree was written in the careful, comprehensive language that legal scholars loved. It specified that the prohibition applied to beasts of burden, fowl of all descriptions, creatures of the field and forest, and any other animal whether tame or wild. It included penalties ranging from fines to loss of title for violations. It even addressed the specific issue of armor for animals, noting that such equipment could only be used for legitimate military purposes, though quite what legitimate military purposes a goose might serve was left unexplored. The law was adopted throughout the Holy Roman Empire and spread to other parts of Europe as well. For decades afterward, legal scholars would cite the Goose Decree when dealing with cases involving the improper treatment of animals or the misuse of noble titles. But the law had consequences that no one anticipated. By explicitly stating that animals could not hold titles or participate in human ceremonies, it actually clarified and strengthened the legal status of legitimate nobility. It reinforced the idea that knighthood was a sacred trust that could not be mocked or trivialized. More importantly, it established the principle that legal privilege came with legal responsibility. Knights enjoyed special rights because they served special functions in society. They couldn't simply give those rights to their pets for entertainment purposes. The Goose Decree might have started as a response to one man's peculiar sense of humor, but it became an important step in the evolution of medieval political thought. It helped establish the idea that social institutions were too important to be treated as jokes, and that even the most powerful nobles were bound by law and custom. Sir Hiss of the Pond became something of a folk hero in Central Europe. Storytellers embellished the tale with each telling, until the goose became a symbol of innocent creatures caught up in human folly. Some versions claimed his spirit haunted tournaments, flapping invisibly over tilting fields as a reminder that pride goeth before a fall. The story spread throughout Europe, becoming a favorite tale in noble courts. It was told as a warning against the dangers of treating sacred institutions as sources of entertainment, but also as a celebration of the unpredictable power of nature to humble human pretensions. Medieval artists incorporated the image of an armored goose into everything from illuminated manuscripts to church carvings. The motif became a symbol of the foolishness of human pride and the wisdom of accepting one's proper place in the divine order. But perhaps the most lasting legacy of Sir Hiss was the legal principle his brief career established: that law must be taken seriously, even when dealing with the absurd. The Goose Decree showed that medieval legal systems were sophisticated enough to distinguish between legitimate custom and mere entertainment, between sacred tradition and profane mockery. In a world where the line between the serious and the silly was often blurred, the law provided clarity, and sometimes, apparently, it took a goose to teach that lesson. If Sir Hiss taught medieval Europe about the limits of humor, then Count Heinrich von Schwarzburg was about to teach them about the limits of liquid courage. The year was 1364, somewhere in the German states of the Holy Roman Empire. The exact location is lost to time, but the consequences would ripple across European law for centuries to come. It was a typical autumn tournament season. That golden time when the harvest was in, the weather was still pleasant, and knights across Europe gathered to display their skills and settle their feuds in supposedly civilized combat. Heinrich von Schwarzburg was typical of his class, a minor noble with a major ego, a decent warrior with an indecent thirst for glory, and absolutely no sense of when to stop drinking. Medieval knights were expected to drink. It was part of their social identity. Wine and ale flowed freely at tournaments, partly because medieval water was often unsafe, but mostly because alcohol was seen as a social lubricant that encouraged the kind of boisterous camaraderie that knightly culture valued. But Heinrich took it further than most. He insisted, loudly and to anyone who would listen, that he fought better when spiritually fortified. He claimed that alcohol sharpened his reflexes, steadied his hand, and opened his mind to divine guidance. This was not entirely unreasonable. Medieval medicine taught that wine and ale had medicinal properties, and many knights did indeed find that a drink or two calmed their pre-combat nerves. The problem was that Heinrich never stopped at one or two. On this particular day, Heinrich had started drinking at dawn. Not unusual for a tournament day, when knights often began their preparations hours before the actual events. But by the time the first joust was called, witnesses reported that he was swaying in the saddle, had dropped his lance 3 times while trying to mount his horse, and was loudly proclaiming that "the glory of St. Michael guides my aim." This might have been merely embarrassing if Heinrich had been competing against other knights. Medieval tournaments had strict rules about safety, and officials would normally have removed an obviously impaired participant before he could hurt himself or others. But Heinrich wasn't tilting against a fellow knight that day. He was participating in a demonstration bout against a practice quintain, a rotating wooden target designed to test accuracy and timing. It was supposed to be a safe, controlled exhibition that would warm up the crowd before the main events. Instead, it became a masterclass in how alcohol and medieval weapons don't mix. Heinrich charged the quintain with all the enthusiasm of a knight facing mortal combat. He missed the target entirely, not unusual, even for sober knights, as quintain work required precise timing and coordination. But instead of pulling up after his failed pass, Heinrich continued his charge straight into the crowd of spectators. Specifically, he rode directly into a group of monks who had been invited to bless the proceedings and pray for the safety of all participants. The scene that followed was like something from a dark comedy. Heinrich's lance, still couched for combat, struck Brother Marcus of Würzburg squarely in the chest. The monk flew backward into his fellow brothers, creating a domino effect of falling holy men. Heinrich's horse, trained for battle but confused by the lack of enemy response, continued charging through the clerical casualties while its rider shouted benedictions in Latin. By the time Heinrich finally brought his mount under control, he had managed to injure 3 monks, scatter Blessed Communion wafers across the tournament ground, and completely destroy a portable altar that had been set up for the pre-tournament mass. The immediate aftermath was chaos. The injured monks were carried away on stretchers, trailing blood and protests in equal measure. The tournament officials huddled in emergency conference. The crowd, initially silent with shock, began to murmur about divine judgment and the wrath of God. But it was Brother Marcus who provided the day's most memorable quote. As he was carried away, supposedly dying from his wounds, he raised his head and declared, "I came here to pray for the knight's safety. I should have prayed for my own." Brother Marcus, I'm happy to report, recovered completely and lived to the ripe old age of 73, though he spent the rest of his life carefully avoiding outdoor sporting events. The incident sent shockwaves through medieval society that went far beyond the tournament grounds. The church was horrified, not just by the injury to holy men, but by the obvious mockery that Heinrich's behavior represented. Secular authorities worried about the precedent it set. If knights could attack clergy with impunity while claiming to be under divine guidance, what did that do to the carefully balanced relationship between church and state? Duke Frederick of Swabia, in whose territory the tournament took place, convened an emergency council within days of the incident. The gathering included legal scholars, church officials, representatives of the knightly orders, and even some of the common burghers whose taxes supported the whole feudal system. Their task was to determine what laws had been broken and what measures should be taken to prevent similar incidents. But as they delved into the existing legal codes, they discovered something remarkable. There was no law specifically prohibiting knights from competing while drunk. Medieval law was enormously complex, covering everything from the proper treatment of serfs to the correct procedures for blessing holy water. But somehow, in all those centuries of legal development, no one had thought to explicitly ban intoxicated knights from tournament competition. This was partly because such behavior was traditionally controlled by honor codes rather than written law. Knights were expected to conduct themselves with dignity and skill. Those who failed to meet these standards would be shamed by their peers, excluded from future events, or stripped of their privileges by their feudal superiors. But Heinrich's case was different. He hadn't just embarrassed himself. He had injured clergy in what appeared to be a deliberate attack on the church itself. This required a legal response, not just social disapproval. The result was groundbreaking. Europe's first law specifically prohibiting impaired operation of medieval vehicles, in this case, war horses. The statute, formerly known as the Decree on Knightly Sobriety and Martial Exercises, was remarkably comprehensive for a law that emerged from a single incident. It prohibited any knight, squire, or man-at-arms from participating in tournaments, melees, or formal combat while under the influence of wine, ale, spirits, or any other substance that might impair judgment or coordination. The law defined specific penalties for violations, ranging from exclusion from future tournaments, to loss of knightly privileges. It established procedures for testing suspected violators, essentially medieval field sobriety tests involving balance, coordination, and the ability to recite prayers in Latin without slurring. Most remarkably, it created a new category of legal responsibility. For the first time in European law, being intoxicated was not considered a mitigating factor in criminal behavior, but an aggravating one. If you injured someone while drunk, your punishment would be more severe, not less, because you had chosen to put yourself and others at risk. This was revolutionary thinking. Medieval legal systems generally treated intoxication as evidence of diminished capacity, similar to madness or extreme youth. But the Heinrich case established the principle that people were responsible for their decision to drink, and therefore responsible for any consequences that followed. Not everyone was pleased with the new law. Knights throughout the empire protested that it interfered with their traditional rights and customs. They argued that moderate drinking was part of knightly culture, that it helped build the camaraderie essential to military effectiveness, and that complete sobriety would actually make tournaments more dangerous by increasing tension and reducing the social bonds between participants. Some even claimed that the law was discriminatory since it only applied to the nobility. Peasants, they pointed out, were free to drink themselves into oblivion without legal consequence. Why should knights be held to a higher standard? The Church supported the law enthusiastically, seeing it as both a practical safety measure and a moral statement about the importance of self-control. Secular authorities were more divided, with some viewing it as necessary reform and others seeing it as an unnecessary restriction on noble privilege. Enforcement proved challenging. Medieval tournaments didn't have breathalyzers, so officials had to rely on observation and testimony to determine whether participants were impaired. This led to elaborate procedures involving balance tests, recitation of prayers, and evaluation of a knight's ability to control his horse. The decree on knightly sobriety spread throughout Europe with surprising speed. Within a decade, similar laws had been adopted in France, England, and the Italian city-states. Each region adapted the basic principles to their own legal systems and cultural norms, but the core concept remained the same. With privilege comes responsibility, and those who wield weapons must do so soberly. The law also established important precedents for later legal development. It was one of the first European statutes to recognize that someone's mental state at the time of an action could affect their legal responsibility for that action. This principle would eventually evolve into modern concepts of criminal intent and diminished capacity. More immediately, it changed the culture of medieval tournaments. The raucous, alcohol-soaked celebrations that had characterized earlier events gave way to more controlled, formal ceremonies. Knights still drank, but they did so after their martial duties were complete, not before. As for Heinrich von Schwarzburg himself, his story had an unexpectedly positive ending. Publicly humiliated by the incident and facing significant legal penalties, he underwent what medieval sources describe as a genuine conversion experience. Heinrich became a patron of the monastery where Brother Marcus recovered from his injuries. He endowed a chapel specifically dedicated to the safety of tournament participants. Most remarkably, he became one of the most effective advocates for the very law that his behavior had created. Heinrich spent his later years traveling throughout the empire, speaking to young knights about the dangers of combining alcohol with martial activities. His talks, described by chroniclers as both humorous and moving, apparently had significant impact. Several sources credit him with preventing numerous potential accidents through his educational efforts. He lived to be 62, dying peacefully in his bed, a notable achievement for a medieval knight. At his funeral, Brother Marcus delivered the eulogy, praising Heinrich as a man who had learned from his mistakes and dedicated his life to preventing others from making similar ones. The tombstone inscription, which survives to this day, reads simply, "He rode with angels, but learned to walk with men." In medieval England, bread wasn't just food. It was politics you could eat. Every loaf was regulated by law, every baker was watched by officials, and every crumb carried the weight of royal authority. The Assize of Bread and Ale, one of the most comprehensive regulatory frameworks in medieval Europe, dictated everything about bread production: size, weight, price, and quality. But nowhere in all those detailed regulations was there a single word about shape. That oversight would lead to one of the strangest treason trials in English history. The year was 1327, during the turbulent early reign of Edward III. England was still recovering from the chaos of Edward II's deposition and murder. The country was perpetually on the edge of war with Scotland, and everyone in power was hypersensitive to anything that might be construed as criticism of royal authority. In this atmosphere of paranoia and political tension, a baker in London was about to discover that artistic expression could be a dangerous thing. His name was William Baker. Yes, really, William Baker the baker, because medieval people were nothing if not literal in their naming conventions. William was, by all accounts, a skilled craftsman, known for producing bread that was both delicious and beautiful. In an age when most bread was rough, dense, and purely functional, William took pride in creating loaves that were as pleasing to the eye as they were to the palate. He decorated his bread with intricate patterns pressed into the dough before baking. He shaped loaves into elaborate forms, braids, flowers, even simple animal shapes for special occasions. His bakery was popular with London's emerging middle class, merchants and guildmasters who could afford to pay a little extra for bread that announced their prosperity. Medieval baking was strictly regulated, but the regulations focused on practical matters, ensuring that bakers didn't cheat customers on weight, that they used proper ingredients, that they charged fair prices. The authorities cared about nutrition and economics, not aesthetics. So when William decided to create his masterpiece, a large round loaf decorated with an elaborate pattern around the edge, he had no reason to think he was doing anything wrong. The loaf was precisely the correct weight according to the assize. It was made from the finest white flour. It was priced fairly according to established guidelines. The only unusual thing about it was its appearance. The decoration that William pressed into the dough was, by medieval standards, a work of art. A raised pattern ran around the circumference of the loaf, creating a band of intricate geometric designs. At regular intervals, the pattern rose to small peaks, giving the entire decoration a distinctive appearance. To William, it was simply beautiful bread. To his customers, it was an example of the kind of craftsmanship that made London's bakers the envy of Europe. To Thomas de Grey, a royal clerk who happened to pass by William's shop, it looked exactly like a crown. Not just any crown, but specifically the crown of England, the sacred symbol of royal authority, the physical manifestation of divine right, the most potent political symbol in the kingdom. De Grey stood outside William's shop, staring at the display of decorated loaves, his mind racing through the political implications. Here was a common baker, a man of no rank or standing, creating bread that mimicked the most sacred symbol of monarchy. Was this deliberate mockery? A subtle form of sedition? An attempt to diminish royal authority by reducing it to something as common as daily bread? In the paranoid atmosphere of 14th century politics, such questions weren't academic. Criticism of the monarchy, even implied criticism, was treason, and treason was a capital offense. De Grey reported his concerns to his superiors, who took them seriously enough to launch a formal investigation. Royal officials visited William's bakery, examined the suspect loaves, and questioned the baker about his intentions. William's response was probably the most honest and naive statement ever made in a treason investigation. "I just thought it looked pretty." But honesty and naivety were not defenses against charges of sedition. The officials confiscated several loaves as evidence and began building a case against the baker. They interviewed his customers, looking for evidence that William had encouraged treasonous thoughts. They examined his other bread designs, searching for patterns of anti-royal sentiment. What they found was a man guilty of nothing more than artistic ambition and poor timing. William had never shown any interest in politics. He had never made statements critical of the king. His only crime was creating bread that accidentally resembled royal regalia. But in medieval England, intent was often less important than appearance. The law of treason was deliberately vague, covering not just active rebellion, but any behavior that might diminish the dignity of the crown. And what could be more diminishing than turning the symbol of royal authority into a bakery product? William Baker's trial was conducted with all the solemnity of a major state prosecution. The charges were read formally: creating bread, in the form and likeness of the royal crown, thereby diminishing the majesty and authority of our sovereign lord the king. The evidence was presented to a jury of London citizens. The crown-shaped loaves were exhibited, their suspicious resemblance to royal regalia duly noted. Witnesses testified to the baker's skill and artistic pretensions. The prosecution argued that William's actions, whether intentional or not, constituted an attack on the fundamental principles of monarchy. By making bread that looked like a crown, he had reduced the sacred symbol of royal authority to the level of common food. This was not just disrespectful, it was dangerous, potentially encouraging others to think of monarchy as something ordinary rather than divinely ordained. William's defense, that he had meant no harm and was simply trying to make beautiful bread, fell on deaf ears. The law, the prosecutor reminded the jury, was concerned with effects, not intentions. If William's bread caused people to think disrespectfully of the crown, then he was guilty regardless of his motives. The jury deliberated for less than an hour before returning a verdict of guilty. William Baker was sentenced to death by hanging, the standard punishment for treason. But his case had attracted considerable public attention, and not all of it was supportive of the prosecution. London's guildmasters, many of them William's customers, petitioned the court for mercy. They pointed out that the baker was a skilled craftsman whose work brought credit to the city. They argued that his artistic ambitions, however misguided, came from a desire to serve his customers better, not to attack the crown. More importantly, the church intervened on William's behalf. Several prominent clergy argued that the case set a dangerous precedent. If artists and craftsmen could be executed for accidentally creating something that resembled royal symbols, where would it end? Would painters be hanged for using too much gold in their religious works? Would stone carvers face death for creating architectural details that might remind someone of a crown? These arguments apparently had some effect. William's death sentence was commuted to public humiliation and a heavy fine. He was placed in the stocks in front of his bakery, wearing a necklace made from his offending loaves, while a herald read the charges against him to any passerby willing to listen. The fine was substantial enough to bankrupt most craftsmen, but William's guild rallied to his support, helping him pay the penalty and restart his business. But William Baker's case didn't end with his punishment. The incident had revealed a significant gap in English law. If royal symbols were so sacred that accidentally reproducing them was treasonous, then perhaps the law should specify exactly what constituted illegal resemblance to royal regalia. Within months of William's trial, Parliament passed what historians call the Baker's Law, a comprehensive statute defining seditious symbolism. The law prohibited any person from creating, selling, or displaying any object that bore unseemly resemblance to royal symbols, including crowns, scepters, royal seals, and coats of arms. The law was remarkably detailed, specifying that the prohibition applied to all manner of crafted goods, including but not limited to works of metal, wood, stone, cloth, and bread. It even included specific guidelines for determining whether a resemblance was unseemly, essentially, whether a reasonable person might mistake the object for an actual royal symbol. The Baker's Law had consequences that no one anticipated. By explicitly defining what constituted seditious symbolism, it actually clarified what was legal. Craftsmen now knew exactly where the boundaries were, and many of them pushed right up to the edge. London's goldsmiths began creating elaborate jewelry that incorporated royal symbols in technically legal ways. Crowns that were obviously crowns, but just different enough to avoid prosecution. Scepters that were clearly scepters, but with sufficient modifications to satisfy the law. This led to a flourishing of creative interpretation that made London one of the centers of decorative arts in medieval Europe. Craftsmen who might have avoided any royal symbolism altogether now competed to see how close they could come to the legal line without crossing it. Perhaps more importantly, William Baker's case changed how medieval people thought about the relationship between art and politics. Before the Baker's Law, artistic expression was generally seen as politically neutral, a craft skill rather than a form of political speech. After the law, everyone understood that art could be political, whether the artist intended it or not. This led to greater self-consciousness among craftsmen, but also to greater sophistication in artistic expression. Medieval artists learned to encode political messages in their work, using symbols and allegories that could be interpreted multiple ways depending on the viewer's perspective and political sympathies. This tradition of artistic double meaning would influence European art for centuries to come. William Baker himself survived his ordeal and went on to have a successful, if more cautious, career. He continued to make beautiful bread, but he was very careful to avoid any designs that might be construed as royal symbolism. Ironically, his fame as the baker who accidentally committed treason actually helped his business. Customers came from across London to see the man who had been tried for making crown-shaped bread. Many of them bought loaves as souvenirs, though William was careful to ensure that none of them resembled anything more politically sensitive than flowers or geometric patterns. In his later years, William became something of a spokesman for craftsmen's rights. He argued that artists should have clear guidelines about what was and wasn't legally acceptable, rather than being left to guess at the political implications of their work. He lived to be 61, dying peacefully in his bed surrounded by family and friends. At his funeral, the guildmaster who delivered his eulogy praised him as a man who had suffered for his art and learned from his suffering. But perhaps the most fitting memorial to William Baker was the continuing popularity of decorative bread in London. The baker's law, intended to suppress artistic expression that might challenge royal authority, actually encouraged a flowering of creative bread-making that made London famous throughout Europe. Sometimes the best way to honor a symbol is to understand its power. And sometimes it takes a baker to teach that lesson. In the rolling hills of medieval Tuscany, sometime in the late 14th century, there stood a monastery that should have been a sanctuary of divine peace. The Abbey of Sant'Angelo was home to 37 Benedictine monks who had sworn vows of poverty, chastity, and obedience. They spent their days in prayer, their evenings in contemplation, and their nights in the dreamless sleep of the righteous. Or at least, that's what they were supposed to do. What they actually did was create one of the most scandalous musical innovations in medieval history, and in the process, establish legal precedents that would govern religious behavior for centuries to come. The story begins with Brother Francesco, a young monk who had joined the community with the best of intentions, but perhaps the worst sense of timing. Francesco had been a popular musician before taking his vows, known throughout Tuscany for his skill with the lute and his knowledge of the secular songs that entertained nobles and merchants in the region's growing cities. When he entered the monastery, Francesco dutifully gave up his worldly pursuits to focus on sacred music. The Benedictine tradition included a rich heritage of liturgical chanting, and Francesco threw himself into learning the ancient melodies that had echoed through Christian monasteries for centuries. But medieval monastic music was, well, let's be charitable and call it challenging. The Gregorian chants that formed the backbone of liturgical music were slow, repetitive, and deliberately austere. They were designed to focus the mind on God rather than entertain the senses. Beauty, when it occurred, was supposed to be ethereal and otherworldly, not the kind of foot-tapping, melody-humming music that Francesco remembered from his secular days. For the first 2 years of his monastic career, Francesco was a model of religious discipline. He learned the traditional chants, participated in the daily offices, and kept his musical innovations to himself. But gradually, almost unconsciously, he began making small changes to the established melodies. A note held a little longer here, a slight variation in rhythm there. Nothing dramatic, nothing that the abbot would notice during the formal services. Just tiny adjustments that made the ancient chants a little more interesting. The other monks began to notice. During evening vespers, they found themselves listening more closely to the music. The familiar melodies seemed somehow fresher, more engaging. They looked forward to the musical portions of the services in a way they never had before. Francesco, encouraged by his brother's attention, began to be bolder in his innovations. He started incorporating musical techniques he remembered from his secular days, harmonies that had never been heard in sacred music, rhythmic patterns borrowed from popular songs, melodic embellishments that made the ancient words seem almost modern. The transformation was gradual, but by the winter of 1384, the musical life of Sant'Angelo had been completely revolutionized. What had once been austere sacred chanting had become something approaching entertainment. The crisis came during the Christmas season, when the monastery's musical activities reached their annual peak. Francesco, now serving as the unofficial choir director, had prepared special arrangements of the traditional Christmas chants. These versions incorporated not just his usual melodic innovations, but actual instrumental accompaniment, lutes, small drums, and even a tambourine that one of the brothers had somehow acquired. The Christmas vigil service that year was unlike anything in the monastery's 300-year history. Instead of the austere, meditative atmosphere that had characterized previous celebrations, the chapel filled with what could only be described as joyful noise. The monks sang with enthusiasm rather than solemnity. Some of them swayed to the rhythm. At least one was caught tapping his foot during what should have been a particularly solemn moment. But the real scandal came after Compline, the final service of the evening. As the monks were supposed to be retiring to their cells for silent contemplation, Francesco initiated what he called additional devotional music. This turned out to be an evening concert featuring popular songs that Francesco had sanctified by changing a few key words. A love song became a hymn to the Virgin Mary. A drinking song was transformed into a celebration of communion wine. A bawdy tavern tune about a faithless lover became a meditation on humanity's wayward relationship with God. The music was undeniably beautiful. It was also undeniably inappropriate for a monastery that had been founded specifically to separate its inhabitants from the pleasures and distractions of the secular world. Abbot Benedetto had been aware that something unusual was happening with the monastery's music, but he had initially welcomed it as a sign of increased religious enthusiasm among his charges. The monks seemed more engaged with their worship, more joyful in their devotions. What could be wrong with that? But the Christmas Vigil concert crossed a line that even the most liberal interpretation of Benedictine tradition couldn't accommodate. When Benedetto discovered that his monks were essentially holding secular concerts in the chapel during hours designated for silent contemplation, he faced a crisis that no manual of monastic governance had prepared him for. The problem was that Francesco's innovations weren't clearly forbidden by existing rules. The Benedictine rule, written by Saint Benedict himself in the 6th century, emphasized the importance of liturgical music, but provided few specific guidelines about what was and wasn't acceptable. Later interpretations had established some traditions, but these weren't formal law. They were customary practices that had evolved over centuries. Francesco's music was certainly innovative, but was it actually heretical? It was entertaining, but was it necessarily inconsistent with religious devotion? It departed from tradition, but did that automatically make it wrong? These questions might seem academic, but in medieval monasticism, they had serious practical implications. Monasteries were largely self-governing, but they were also subject to oversight by church authorities. If the Bishop of Florence decided that Sant'Angelo had strayed from acceptable practice, he could remove the abbot, transfer the monks, or even close the monastery entirely. Word of Sant'Angelo's musical innovations had inevitably reached the outside world. Visitors to the monastery reported hearing sounds more appropriate to a tavern than a sacred place. Local clergy complained that the monks were setting a bad example for lay Christians, who might think that religious observance should be entertaining rather than challenging. Most seriously, a formal complaint was filed with the Bishop of Florence by a neighboring monastery whose own musical traditions suddenly seemed dull by comparison. The complaint alleged that Sant'Angelo had abandoned sacred tradition in favor of worldly entertainment and requested official intervention. Bishop Colonna was a practical man who understood that religious innovation could be either divine inspiration or dangerous deviation, depending on its ultimate effects. He appointed a commission of inquiry consisting of 3 senior clergy, 2 legal scholars, and 1 expert in liturgical music. The commission spent 3 weeks at Sant'Angelo, observing services, interviewing monks, and analyzing Francesco's musical innovations. Their final report was a masterpiece of diplomatic complexity that managed to criticize the monastery's practices while avoiding outright condemnation. The commission found that while Francesco's innovations were technically not heretical, They represented a dangerous departure from established tradition that could lead to confusion among the faithful and diminishment of proper religious reverence. Bishop Kalana's response was swift and comprehensive. He issued what became known as the Decree on Sacred Silence, one of the most important pieces of religious legislation produced in 14th century Tuscany. The decree established specific guidelines for monastic music, requiring that all liturgical singing conform to ancient and approved traditions. It prohibited the use of secular musical forms in religious contexts and banned instrumental accompaniment during certain services. Most significantly for Francesco and his fellow musical innovators, the decree established a silence period, extending from Compline to Lauds, roughly from sunset to sunrise, during which no musical performance of any kind was permitted in monastic settings. The decree didn't just apply to Sant'Angelo. It was distributed to every monastery and convent in the diocese, establishing uniform standards for religious musical practice. Within a decade, similar rules had been adopted throughout Italy and beyond. But the silence decree was about more than just music. It represented a broader effort by church authorities to maintain control over religious innovation at a time when new ideas were emerging throughout European Christianity. The decree had consequences that no one anticipated. By establishing clear boundaries for religious music, it actually encouraged innovation within those boundaries. Composers throughout Europe began experimenting with ways to make traditional chants more beautiful and engaging while staying within the new legal requirements. This led to an extraordinary flowering of liturgical music that historians now call the late medieval sacred Renaissance. Composers learned to create complex harmonies using only approved melodic forms. They developed new ways of setting traditional texts that were both legally acceptable and genuinely inspiring. The requirement that religious music be clearly distinguishable from secular forms also encouraged the development of distinctively sacred musical languages. Instead of adapting popular songs for religious use, composers began creating entirely new forms of music that could only be used in religious contexts. Francesco himself became one of the leading figures in this movement. Chastened by the investigation but not discouraged, he dedicated himself to creating music that was both innovative and traditionally acceptable. His later compositions, written entirely within the constraints established by the Silence Decree, are now considered masterpieces of medieval sacred music. The Silence Decree established important precedents that extended far beyond music. It was one of the first pieces of church legislation to address the question of religious innovation in systematic detail, establishing principles that would influence Catholic law for centuries. The decree recognized that tradition could evolve, but only under carefully controlled circumstances. It established procedures for evaluating religious innovations, requiring that changes be approved by appropriate authorities before being implemented. Most importantly, it affirmed the Church's authority to regulate not just doctrine, but practice, not just what people believed, but how they expressed those beliefs. This principle would become central to Counter-Reformation efforts to standardize Catholic worship across Europe. Life at Sant'Angelo changed dramatically after the decree's implementation. The joyful, innovative musical culture that Francesco had created was replaced by careful adherence to traditional forms. The evening concerts ended. The instrumental accompaniments disappeared. The ancient chants resumed their austere, meditative character. But something had been permanently altered in the monastery's spiritual life. The monks who had experienced Francesco's innovations never forgot what worship could be like when it engaged their emotions as well as their intellect. They found ways to bring that same sense of engagement to traditional forms, discovering depths in ancient chants that they had never noticed before. Francesco continued to serve at Sant'Angelo for another 23 years, becoming one of the most respected musicians in Tuscany, while remaining scrupulously faithful to the Silence Decree. He trained dozens of younger monks in the art of sacred music, passing on not just technical skills but a deep understanding of how music could serve spiritual purpose. When he died in 1408, his funeral featured music that was entirely traditional in form, but unprecedented in its emotional power. The ancient chants that the monastery had sung for centuries seemed to contain all the innovation and creativity that Francesco had once brought to secular melodies. The story of Sant'Angelo's musical revolution illustrates one of the central tensions of medieval Christianity, the balance between tradition and innovation, between preserving sacred practices and allowing them to evolve with changing times. Francesco's innovations weren't motivated by rebellion against religious authority or desire to secularize sacred practices. They emerged from genuine devotion and a sincere belief that beautiful music could enhance rather than detract from religious experience. But medieval Christianity was built on the principle that some things were too important to be left to individual judgment. Sacred traditions had been carefully developed over centuries to serve specific spiritual purposes. Changing them, even with the best intentions, could have consequences that no one could foresee. The silence decree represented the Church's attempt to preserve what was essential while allowing room for appropriate growth. It wasn't a blanket prohibition on innovation, but an effort to ensure that changes served spiritual rather than merely aesthetic purposes. In the end, Francesco's musical innovations did transform sacred music, just not in the way he originally intended. By forcing him to work within traditional constraints, the decree pushed him to discover possibilities in ancient forms that might never have been explored otherwise. Sometimes the best way to encourage creativity is to establish clear boundaries within which it can flourish, and sometimes it takes a rebellious monk with a lute to teach that lesson. In the rolling countryside of medieval England, where sheep grazed on emerald hills and ancient oaks cast shadows over babbling brooks, there lived a nobleman who had perhaps the most personal relationship with his livestock in recorded history. Lord Humphrey de Catrick was a man of modest holdings but immoderate attachment to his carp pond, a relationship that would ultimately create some of the most bizarre legal precedents in English jurisprudence. Lord Humphrey's estate, nestled in the Yorkshire Dales, was typical of minor noble holdings in 15th century England. He had a modest manor house, several hundred acres of farmland, a mill, and various livestock that provided both sustenance and income for his household. But the crown jewel of his property was an artificial pond that he had commissioned at considerable expense, stocked with prize carp imported from the Low Countries. These weren't ordinary fish. Medieval carp were symbols of prosperity and sophistication, expensive delicacies that only the wealthy could afford to maintain. Humphrey's carp pond was both a practical investment and a status symbol, demonstrating his wealth and refined tastes to visiting neighbors and potential marriage prospects for his daughters. But Humphrey's relationship with his fish went far beyond mere ownership. Contemporary accounts describe him speaking to the carp as one might address faithful servants, consulting them before making important decisions, and even claiming that their swimming patterns could predict the weather and the outcome of legal disputes. This behavior might have remained a harmless eccentricity if not for the events of the summer of 1447. It began as a typical season in the Yorkshire countryside. The harvest looked promising, the weather was pleasant, and Lord Humphrey's various enterprises were prospering. The annual Midsummer Festival had been particularly successful, with visitors from neighboring estates coming to admire Humphrey's gardens, sample his ale, and observe his famous carp. But in the days following the festival, Humphrey noticed that his fish were behaving strangely. Instead of their usual sedate movements around the pond, they were swimming in erratic patterns, sometimes moving so quickly that they created visible wakes on the water's surface. Occasionally they would leap partially out of the water, creating splashes that could be heard from the manor house. To most observers, this would have seemed like normal fish behavior, perhaps triggered by changes in water temperature or the presence of insects. But to Humphrey, who claimed to understand the subtle communications of his aquatic companions, the erratic swimming was clearly a sign of distress. After several days of careful observation, Humphrey reached a conclusion that seemed obvious to him, but astounding to everyone else. His fish were drunk. Humphrey's theory was not entirely unreasonable by medieval standards. The Midsummer Festival had involved considerable consumption of ale and wine, and it was possible that some of this alcohol had found its way into the pond. Medieval people understood that animals could be affected by alcohol. They had observed the effects of fermented fruit on birds, and knew that horses could become intoxicated if they consumed spoiled grain. But fish were different. No one in 15th century England had any experience with aquatic alcohol consumption, largely because no one had ever been foolish enough to pour good ale into a valuable carp pond. Humphrey's first step was to summon the local reeve, Thomas Whitmore, to investigate the matter officially. Whitmore arrived expecting to deal with a simple case of livestock illness, perhaps requiring the services of someone with veterinary knowledge. Instead, he found Lord Humphrey standing beside his pond with a long stick, allegedly conducting sobriety tests on his carp. The testing procedure, as Humphrey explained it, involved prodding the fish gently and observing their responses. Sober fish, he claimed, would swim away in straight lines. Intoxicated fish would weave erratically or fail to respond appropriately to stimulation. By these standards, every fish in the pond was thoroughly drunk. Whitmore dutifully recorded Humphrey's claims and began questioning festival attendees about their activities near the pond. What emerged was a story that seemed to confirm Humphrey's worst suspicions. Several young men from neighboring estates, apparently emboldened by festival ale, had engaged in what they described as fish toasting, a drinking game that involved taking swigs of ale and then pouring small amounts into the pond while making elaborate wishes for the fish's health and prosperity. The practice had seemed harmless at the time. Medieval people regularly blessed their livestock with holy water and believed that sharing food and drink with animals could bring good fortune. The young men had intended the fish toasting as a gesture of respect and celebration, not sabotage. But Humphrey saw it differently. In his view, the villagers had deliberately intoxicated his valuable fish, potentially damaging their health and certainly disturbing their peace. This wasn't harmless celebration. It was assault on his property and, given his personal relationship with the fish, an attack on his household. Humphrey demanded that formal charges be filed against the fish tasters for willful inebriation of aquatic creatures and disturbance of piscine tranquility. Whitmore found himself facing a legal question that no English court had ever considered. Could fish be victims of a crime? And if so, what penalties should apply to their alleged intoxication? Medieval English law was remarkably comprehensive, covering everything from the proper treatment of serfs to the correct procedures for conducting trials by ordeal. But nowhere in the legal codes was there any reference to the deliberate intoxication of fish. This presented both practical and theoretical problems. If Humphrey's carp had indeed been harmed by unauthorized alcohol consumption, what was the appropriate legal remedy? How could one determine whether fish were actually intoxicated rather than simply responding to natural environmental changes? And what penalties should apply to people who, however foolishly, had intended no harm? Whitmore consulted with the local sheriff, who consulted with the circuit judge, who eventually sought guidance from legal scholars at Oxford. The case generated considerable debate among experts in English common law, who found themselves exploring questions of animal rights, property damage, and the legal definition of intoxication. The resulting trial was unlike anything in English legal history. The defendants, 3 young men aged 16 to 22, were charged with malicious inebriation of noble fish and trespass against aquatic property. The evidence presented was both detailed and bizarre. Humphrey himself testified at length about the normal behavior patterns of his fish and the dramatic changes he had observed following the festival. He presented what he claimed was expert testimony about carp psychology and the effects of alcohol on fish metabolism. The defendant's attorney argued that his clients had intended no harm and that their actions constituted at worst harmless mischief. He pointed out that no one had been injured, that the fish appeared to have suffered no lasting damage, and that the entire incident was based on speculation rather than proven facts. But the most memorable moment in the trial came when the judge insisted on personally inspecting the allegedly intoxicated fish. The entire court, judge, jury, attorneys, defendants, and numerous spectators, trooped out to Humphrey's pond for what became known as the Great Fish Examination of 1447. The judge observed the fish for nearly an hour, prodding them with sticks and consulting with Humphrey about their behavior patterns. His eventual conclusion was diplomatically vague. While he could not definitively determine whether the fish were intoxicated, their behavior was uncommonly animated and could reasonably be attributed to external influences. The jury found the defendants guilty of property damage but rejected the more serious charges of malicious intent. They were sentenced to pay modest fines and to publicly apologize to Lord Humphrey and his fish. But the real significance of the case lay in the legal precedent it established. The court ruled that animals could be victims of crimes even if they suffered no permanent physical harm, and that property owners had the right to protection from actions that disturbed their livestock, regardless of the perpetrator's intentions. More importantly, the case led to the creation of new legislation specifically addressing the treatment of ornamental and luxury animals. The Statute of Aquatic Protection, passed by Parliament in 1449, prohibited the unauthorized introduction of any substance into waters containing valuable fish. The fish tasting case, as it came to be known, established several important legal principles that extended far beyond the specific issue of drunk carp. First, it recognized that property rights included protection from actions that diminished the owner's enjoyment of his possessions, even if those actions caused no measurable economic damage. This principle would later be applied to cases involving noise pollution, aesthetic damage, and other forms of nuisance that couldn't be easily quantified. Second, it established that intent was not always relevant in determining legal responsibility. The fish tasters had meant no harm, but they were still held accountable for the consequences of their actions. This helped clarify the boundaries of strict liability in English law. Third, it recognized that animals could have legal standing as victims, even if they couldn't represent themselves in court. This was a remarkably progressive concept that wouldn't be fully developed in English law for several more centuries. Beyond its legal significance, the fish tasting case became a source of entertainment and moral instruction throughout England. Storytellers embellished the tale with each retelling, until Lord Humphrey became a folk hero, celebrated for his dedication to his aquatic companions. The story was used to teach lessons about the importance of respecting others' property, the dangers of excessive drinking, and the unintended consequences of seemingly harmless actions. It appeared in moral treatises, children's stories, and even religious sermons as an example of how small sins could lead to large troubles. Artists incorporated the image of drunk fish into everything from tavern signs to church decorations. The motif became a symbol of the chaos that could result from abandoning proper social boundaries and the importance of maintaining order in both human and animal communities. Humphrey himself became something of a celebrity, known throughout England as the lord who had successfully prosecuted the poisoners of his fish. He used his fame to become an advocate for animal welfare, arguing that owners had moral as well as legal obligations to protect their livestock from harm. He spent his later years developing what he called scientific fish husbandry, creating detailed records of his carp's behavior patterns and health indicators. His notes, preserved in the British Library, are among the earliest systematic observations of fish behavior in English literature. When Humphrey died in 1461, his funeral was attended by nobles from throughout Yorkshire, many of whom brought gifts of rare fish to stock his memorial pond. The inscription on his tomb reads, "Here lies a man who spoke with fish and taught them to speak with law." The legal framework established by the fish tasting case proved remarkably durable. Similar laws protecting ornamental animals were adopted throughout Europe, and many of the principles established by the case remain part of English property law today. The case also established precedents for what we now call environmental law. The idea that property owners could seek legal remedies for actions that disturbed their land use, even without direct physical damage, became an important tool for protecting both private property and public resources. Modern animal welfare legislation can trace some of its intellectual foundations to the fish tasting case and similar medieval precedents that recognized animals as more than mere property. The case helped establish the principle that humans had legal obligations to the creatures under their care, regardless of those creatures' economic value. Perhaps most importantly, the case demonstrated that medieval legal systems were flexible enough to address entirely new types of problems. When faced with a situation that no law had anticipated, English courts were able to develop new principles that served both justice and practical social needs. Sometimes the most important legal innovations come from the most unexpected sources, and sometimes it takes a nobleman talking to his fish to remind us that law exists to protect all members of the community, even the ones who can't speak for themselves. In the summer of 1324, the French town of Sens was blessed with a magnificent new church bell. cast from the finest bronze by master craftsmen from Flanders, decorated with intricate religious imagery, and blessed by the bishop himself. The bell was intended to be the crown jewel of the newly completed Cathedral of Saint-Étienne. The bell was massive, nearly 8 feet in diameter and weighing over 4 tons. It had cost the town a fortune, funded by special taxes and donations that had required 3 years to collect. The casting alone had taken 6 months, with the bronze heated in specially constructed furnaces and poured in a ceremony that attracted spectators from across the region. The bell represented more than just a call to prayer. In medieval France, church bells were the voices of communities, marking the rhythms of daily life, announcing celebrations and tragedies, calling people together in times of crisis. A great bell was a source of civic pride, a symbol of prosperity and divine favor. The craftsmen who created this particular bell had outdone themselves. The bronze was perfectly alloyed for optimal resonance. The shape was mathematically precise to produce the most beautiful tone. The decorative reliefs told the story of salvation in intricate detail, from the Annunciation to the Resurrection. But this bell, destined to call the faithful to prayer for centuries to come, would ring exactly once before becoming the defendant in one of the most unusual criminal trials in French history. The problem began during the bell's inaugural ceremony. The townspeople of Sens had gathered in the cathedral square to hear their magnificent new bell for the first time. The bishop offered a final blessing. The bell ringer took his position at the rope. A hush fell over the crowd as hundreds of faces turned upward toward the tower. The bell rang out with a voice that was everything the townspeople had hoped for. Deep, resonant, and beautiful enough to make grown men weep with joy. For a moment, it seemed that the years of sacrifice and expense had been justified. The sound rolled across the medieval town like a wave of pure music, echoing off stone buildings and touching hearts throughout the community. Then the storm arrived. Medieval people were accustomed to sudden weather changes, but the storm that struck Sens that afternoon was unlike anything in living memory. It appeared literally out of nowhere. One moment the sky was clear. The next it was black, with clouds that seemed to boil with supernatural fury. The wind arrived first, strong enough to knock people off their feet and tear the decorative banners that had been hung for the bell ceremony. Market stalls collapsed. Roof tiles flew through the air like deadly projectiles. People scrambled for whatever shelter they could find, pressing themselves against building walls and diving into doorways. Then came hail. Not ordinary hailstones, but ice chunks the size of eggs that shattered windows and sent the crowd scrambling for deeper cover. The sound was deafening, a constant drumming that made conversation impossible and thinking difficult. But the true terror began when the lightning started. Bolt after bolt struck the cathedral, illuminating the Gothic spires in stark, terrifying detail. The thunder was so loud that several witnesses claimed it drowned out even the screams of the panicking crowd. Each lightning strike seemed more violent than the last, as if the storm was building towards some terrible climax. People began to pray aloud, convinced they were witnessing divine wrath. Some fell to their knees in the square, ignoring the hail and wind, begging God for mercy. The final lightning strike was different from all the others. Instead of the brief, brilliant flashes that had preceded it, this bolt seemed to hang in the air for an impossible moment, connecting heaven and earth in a column of pure white fire. When it struck the bell tower, the sound was like the world itself splitting apart. The light was so bright that people covered their eyes, but they could still see it through their eyelids. The thunder that followed wasn't just heard, it was felt, a physical force that seemed to shake the very foundations of the earth. When the light faded and the thunder ended, the crowd looked up to see their magnificent new bell tumbling from the tower like a bronze meteor, trailing sparks and destruction in its wake. What happened next would be debated by witnesses for decades. The bell, dislodged from its mounting by the lightning strike, crashed through the floor of the bell chamber and began a destructive journey through the cathedral that seemed almost purposeful in its malice. First, it demolished the carved wooden screen that separated the choir from the nave, a masterpiece of medieval craftsmanship that had taken 20 years to complete. The screen had been carved by master artisans from the finest oak, decorated with scenes from the life of Christ, and polished to a warm golden gleam. In seconds, it was reduced to splinters and dust, but the bell didn't stop there. It continued its rampage, smashing through a marble column that had supported the cathedral's roof since the 12th century. The column, carved from a single piece of stone and decorated with intricate capitals, had been considered one of the finest examples of Romanesque sculpture in France. The bell reduced it to rubble. The destruction inside the cathedral was systematic and thorough, but the bell's path didn't end at the building's walls. It burst through the massive oak doors at the building's entrance, doors that had been crafted to withstand armies and had never been breached by human force. Once outside, the bell continued rolling down the cobblestone streets of Sens like some kind of bronze juggernaut, leaving a trail of destruction that grew with each turn. Witnesses described the bell's progress through the town as eerily deliberate. It seemed to seek out the most valuable and fragile targets with uncanny precision. First, it destroyed a silk merchant's shop, crushing bolts of expensive fabric imported from the Orient and scattering precious dyes across the street. Next, it crushed a cartload of imported wine that had been parked outside a tavern. The cart belonged to a merchant who had spent months arranging the purchase of fine vintages from Burgundy and the Loire Valley. In moments, his entire investment was destroyed, the wine mixing with the mud and debris to create crimson streams that ran through the gutters. The bell then demolished a goldsmith's workshop, scattering precious metals and half-finished jewelry across the square. Master craftsmen watching from nearby buildings wept openly as they saw months of delicate work destroyed in seconds. Finally, the bell came to rest only after demolishing a fruit vendor's stall and embedding itself in the wall of the town's most expensive inn. The impact was so violent that it cracked the inn's foundation and brought down part of the second floor. By the time the bell finally stopped moving, it had caused more destruction in 10 minutes than most natural disasters managed in hours. The property damage was enormous, thousands of livres worth of goods and buildings destroyed. But more troubling than the material loss was the sense among the townspeople that they had witnessed something that defied natural explanation. In medieval France, nothing happened by accident. Every event, from the smallest personal misfortune to the greatest natural disaster, was understood to occur within God's divine plan. When lightning struck a church, it wasn't a random meteorological event. It was a message from heaven. But what was the message? Had God rejected the bell? Was he displeased with the town of Sens? Had the cathedral somehow offended divine sensibilities? These questions weren't merely theological. They had practical implications for a community that depended on divine favor for everything from good harvests to protection from enemies. The Bishop of Sens, faced with the most unusual crisis of his ecclesiastical career, convened a committee of theologians to investigate the spiritual implications of the bell's behavior. Their task was to determine whether the bell's destructive rampage was an act of God, an act of the devil, or, most disturbing of all, an act of free will by an inanimate object that had somehow acquired the ability to make moral choices. The investigation took weeks. Witnesses were interviewed repeatedly, their accounts carefully recorded and compared. The bell's construction was examined for signs of demonic influence. Had the bronze been tainted during the casting? Had the craftsman unknowingly incorporated cursed materials? Had enemies of the church somehow sabotaged the blessing ceremony? The cathedral's foundation was inspected for evidence of ancient curses or pagan contamination. Scholars pored over historical records, looking for any precedent that might explain how a blessed object could turn violent. Finally, the committee reached a conclusion that satisfied no one but seemed unavoidable given the evidence. The bell had acted with deliberate malice in its assault on the town. Whether this malice was divinely inspired, demonically influenced, or somehow intrinsic to the bell itself could not be determined. But if the bell had acted deliberately, then it could be held legally responsible for its actions. The trial of the Bell of Sens was conducted with all the solemnity that French legal tradition could muster. The bell, still embedded in the wall of the damaged inn, was formally charged with malicious destruction of property, assault upon sacred structures, and disturbing the peace of Christian souls. Since the bell could not speak in its own defense, the court appointed an advocate, a young lawyer named Philippe de Montmorency, who would later become one of the most respected legal scholars in France, though he always claimed that defending an inanimate object was the most challenging case of his career. De Montmorency's defense strategy was necessarily creative. He argued that the bell was a victim rather than a perpetrator, an innocent object that had been struck by lightning and thrown from the cathedral through no fault of its own. The destruction that followed, he claimed, was the result of natural forces, not deliberate action. The prosecution, led by the town's senior magistrate, countered with what they called evidence of malicious intent. They pointed to the seemingly deliberate path the bell had taken through the town, its apparent targeting of valuable property, and its final act of embedding itself in a building rather than simply rolling to a harmless stop. Expert witnesses testified about the normal behavior of falling objects, the patterns typically seen in storm damage, and the theological implications of blessed objects causing destruction. The case attracted attention from across France, with legal scholars traveling to Sens to observe the proceedings. The trial lasted 3 days and attracted spectators from across France. Legal scholars came to observe the proceedings. Theologians attended to ensure that proper attention was paid to the spiritual implications. Even foreign dignitaries sent observers, curious about how French justice would handle such an unprecedented case. The jury's verdict was a masterpiece of medieval compromise. They found the bell guilty of property destruction but innocent of malicious intent. The bell had indeed caused enormous damage, but this was the result of circumstances beyond its control, rather than deliberate wrongdoing. The sentence was equally creative. The bell would be exiled from the town of Sens for a period of 7 years, during which time it could not be used for any sacred purpose. After this period of punishment, it could be recast into a new bell that would be free from any taint of criminal behavior. But the case established something more significant than just a punishment for one rogue bell. It created the legal framework for dealing with what medieval jurists called acts of inanimate malice, situations where objects appeared to cause harm through their own agency rather than through human action. Within months of the bell trial, similar laws had been adopted throughout France and beyond. The Statute of Inanimate Responsibility established procedures for dealing with objects that caused harm through apparent agency of their own. The law recognized that while objects could not form intent in the way humans could, they could still be held responsible for damages if their behavior exceeded what could reasonably be expected from natural forces. A falling tree that crushed a house during a storm was an accident. A bell that rolled through town destroying property was a criminal act, even if no human agency was involved. The statute established criteria for determining when an object's behavior constituted criminal activity. The key factors were the apparent deliberateness of the action, the extent of damage caused, and the degree to which the behavior exceeded normal expectations for such objects. Objects found guilty of criminal behavior could be punished through exile, destruction, or purification, a process that involved blessing the object and, in many cases, physically altering it to remove any tendency toward future misbehavior. The Statute of Inanimate Responsibility had consequences that extended far beyond the practical matter of dealing with destructive objects. It represented a sophisticated attempt to address fundamental questions about agency, responsibility, and the nature of causation. By recognizing that objects could be held responsible for their actions, medieval French law was acknowledging that the boundaries between human and non-human agency were more complex than traditional legal theory suggested. This was a remarkable philosophical development that wouldn't be fully explored by academic philosophers for several more centuries. The law also established the principle that responsibility was tied to consequence rather than intent. Whether the bell of Sens had meant to cause destruction was less important than the fact that it had caused destruction through behavior that exceeded normal expectations. This principle influenced the development of strict liability law, the idea that people or entities could be held responsible for damages regardless of their intentions or level of care. The concept that objects could misbehave helped establish the foundation for legal frameworks that would later govern everything from industrial accidents to product liability. The story of the Bell of Sens had a surprisingly positive ending. After serving its 7-year exile in a warehouse outside the town, the bell was indeed recast according to the court's sentence. Master craftsmen from across France participated in the recasting ceremony, which was attended by representatives of the church, the legal profession, and the crown itself. The new bell, christened Redemptio, Redemption, was installed in the Cathedral of Saint-Étienne in 1331. It rang without incident for over 4 centuries, becoming one of the most beloved and reliable bells in France. Its voice was said to be even more beautiful than that of its predecessor, as if the experience of trial and punishment had somehow purified its sound. Local legend claimed that Redemptio's voice could calm storms, heal the sick, and bring peace to troubled souls. Whether these claims were true or merely the product of civic pride, the bell certainly brought peace to the town of Sens, which had worried for 7 years that it remained under divine displeasure. The trial of the Bell of Sens established legal precedents that influenced European jurisprudence for centuries. The concept that inanimate objects could be held responsible for their actions provided a framework for dealing with technological developments that medieval lawmakers could never have imagined. When watermills began causing flooding, when mechanical clocks began disturbing the peace, when cannons began exploding unexpectedly, European courts had legal precedents for addressing these problems. The principle established by the Bell case, that responsibility was tied to consequence rather than intent, provided a foundation for regulating technological innovation throughout the late medieval and early modern periods. The case also influenced the development of international law. The idea that objects as well as people could be subject to legal jurisdiction helped establish principles for dealing with cross-border disputes involving ships, trade goods, and other mobile property. Perhaps most importantly, the Bell of Sens case represents an early example of legal systems grappling with questions about the nature of agency and responsibility that remain relevant today. Medieval jurists, faced with a situation that didn't fit existing legal categories, created new frameworks that acknowledged the complexity of causation in human affairs. Their solution, holding objects responsible for their actions while recognizing that such responsibility was different from human moral agency, was both practical and philosophically sophisticated. It provided a way to address real problems while acknowledging that the universe was more complex and mysterious than human law could fully comprehend. The case also demonstrated the flexibility of medieval legal systems. When confronted with an entirely unprecedented situation, French courts were able to develop new principles that served both practical and spiritual needs. In the end, the Bell of Sens taught medieval Europe that justice could be both pragmatic and transcendent, that law existed to serve human needs, but also to acknowledge divine mystery. Sometimes the most profound legal innovations come from the most unexpected sources, and sometimes it takes a runaway bell to remind us that the law must be flexible enough to address even the most impossible circumstances. As we reach the end of our journey through the bizarre legal landscape of medieval Europe, it's worth reflecting on what these strange cases tell us about the people who created them and the world they were trying to understand. The pig trials, the nightly geese, the drunken fish, the crown-shaped bread, the musical monks, and the runaway bells. All of these cases emerged from a society that was trying to create order in a world that often seemed chaotic and unpredictable. Medieval people lived in a universe where the supernatural was real and immediate, where divine intervention was expected, and where the line between the natural and the miraculous was constantly shifting. Their legal systems reflected this worldview, creating frameworks that could address everything from practical problems to spiritual crises. What strikes modern observers as absurd about medieval law often reflects a different understanding of cause and effect, responsibility and agency, individual rights and community welfare. Medieval people weren't less intelligent than we are. They were operating with different assumptions about how the world worked. When they put a pig on trial for murder, they weren't being foolish. They were applying a sophisticated theological and legal framework that assigned moral responsibility to all of God's creatures. When they banned knights from giving titles to geese, they weren't being petty. They were protecting sacred institutions from trivialization. When they regulated the nighttime activities of musical monks or created dress codes for naked carpenters, They were balancing individual expression against community needs in ways that required considerable legal creativity. Many of the legal principles established by these bizarre medieval cases remain relevant today. The idea that law must balance competing interests, that individual rights must be weighed against community welfare, that legal systems must be flexible enough to address entirely new types of problems. These concepts, developed through cases involving drunken knights and egg-laying roosters, continue to influence modern jurisprudence. The medieval period also established important precedents for administrative law, environmental regulation, workplace safety, and professional ethics. Many modern legal frameworks trace their origins to medieval innovations that emerged from the need to address practical problems in complex societies. Perhaps most importantly, these medieval cases remind us that human nature remains remarkably constant across the centuries. The same impulses that drove medieval bakers to create artistic bread drive modern artists to push creative boundaries. The same community concerns that led to medieval noise ordinances motivate modern quality of life legislation. The same tensions between individual expression and social responsibility that characterized medieval monasteries continue to shape debates about religious freedom in modern societies. The same need to balance practical necessity against social propriety that challenged medieval lawmakers continues to influence contemporary policymaking. The legal innovations we've explored tonight emerged during a particular period in European history, a time when traditional medieval structures were beginning to give way to early modern institutions. Many of these laws were created during times of social transition, when old certainties were breaking down and new approaches were needed. By the late medieval period, the worldview that had produced pig trials and rooster executions was beginning to change. The rise of scientific thinking, the growth of secular authority, and the development of more sophisticated legal institutions gradually reduced the influence of supernatural explanations for unusual events. But the legal frameworks created during the medieval period didn't disappear. They evolved, adapted to new circumstances, and continued to influence European law for centuries to come. What can we learn from these strange tales of medieval justice? Perhaps the most important lesson is that legal systems are human creations, shaped by the beliefs, fears, and aspirations of the people who create them. The laws that seem most bizarre to us today were logical responses to real problems, developed by intelligent people working within their understanding of how the world operated. This should make us humble about our own legal innovations. The laws we create today, based on our current understanding of human nature and social needs, may seem just as strange to future observers as medieval pig trials seem to us. But it should also inspire confidence in human adaptability. Medieval legal systems proved remarkably creative in addressing entirely new types of problems. They developed innovative solutions that balanced competing interests and created workable frameworks for governing complex societies. In our modern world, we've largely abandoned the medieval belief that supernatural forces directly intervene in daily life. We have scientific explanations for most of the phenomena that once seemed magical or demonic. We understand that roosters don't actually lay eggs, that fish can't really get drunk, and that bells don't develop malicious personalities. But perhaps we've lost something in gaining this understanding. Medieval people lived in a world full of wonder and possibility, where miracle and catastrophe were equally possible, where the divine could break through into ordinary life at any moment. Their legal systems, for all their apparent absurdity, reflected a deep conviction that every event mattered, that every creature had significance, that every action had consequences that rippled through both natural and supernatural realms. As we conclude our journey through the strange legal landscape of medieval Europe, it's worth remembering that these weren't just historical curiosities. They were real events that affected real people's lives. Behind every bizarre law was a community trying to solve practical problems, maintain social order, and make sense of a complex and often bewildering world. The pig that was tried for murder, the goose that became a knight, the fish that got drunk, the baker who nearly died for making artistic bread, all of these cases involved real animals and real people whose lives were changed by the legal innovations that emerged from their circumstances. Medieval law may seem strange to us, but it emerged from the same human needs that motivate legal development today. The need for justice, the desire for order, the hope that society can be organized in ways that protect both individual rights and community welfare. In the end, perhaps the most remarkable thing about medieval law isn't how different it was from modern legal systems, but how similar the underlying human concerns remain. People then, as now, wanted to live in communities where they could pursue their dreams, express their creativity, and find protection from forces beyond their control. The laws they created, however bizarre they might seem to us, represented their best efforts to build such communities, and in many ways, they succeeded. So the next time you encounter a law that seems particularly strange or bureaucratic, remember the pig who went to court, the goose who wore armor, the priest who defeated a knight, and the rooster who laid an impossible egg. Remember that every law has a story, that every regulation emerged from real human needs, and that the grand project of human justice continues to evolve, one bizarre incident at a time. Thank you for joining me on this journey through the strange and wonderful world of medieval law. Until next time, sleep well and dream of a world where even pigs could have their day in court.